Good afternoon, everyone. Hello, Mr. Miller.
Good afternoon, Judge. We are waiting and raring to go.
Oh, good to hear. All right, welcome to First Appearance Court. My name is Stephen Zakor. I'm the judge who will be presiding. The purpose of today's hearing is to let you know what you've been charged with, determine if there's probable cause to hold you for those charges, and determine any release conditions if appropriate. Is that Mr. Cruz?
It is, Judge.
And Dino Cruz, you're charged in count 1 with domestic violence injunction. I've reviewed the probable cause affidavit. I do find probable cause. Mr. Linder?
Your Honor, and I've provided copies to the defense. What I'm providing you is, one, a copy of the petition of the current injunction that is in place against Mr. Cruz. There was another permanent injunction that the Ms. Carswell got in 2012, and I believe she withdrew that later.
I did a time for that.
Additionally, I provided you with, he was convicted twice. Well, he had a withhold once and convicted the second time for violating the 2012 injunction against Ms. Carswell. I provided you with one of the reports. I'm unable to get a copy of the PC from the other report. The one I provided you, Your Honor, the bond in that case was set at $50,000. Since then, last year, Mr. Cruz was convicted of battery with a violation of probation. In that case, it's alleged that, well, it's not alleged, it's in the report that the person he committed the battery against, he dislocated his shoulder. Your Honor, as you can see, I am concerned in the, it's mentioned in the petition and in the PC that he has made previous threats to kill. And he just refuses to abide by court orders to stay away from Ms. Carswell.
Okay. So in terms of prior convictions, it's the battery with a violation of probation?
It's a battery with a violation of probation, and he's got a withhold and a conviction on two prior violations of injunction protecting Ms. Carswell.
Okay.
Judge?
Yes, sir.
Mr. Cruz has declined the services of the Public Defender's Office, but he advised me that he was wondering if the court would consider releasing him on house arrest.
Mr. Carswell, I have considered your request to be released on house arrest in light of your criminal history, specifically that involving the same listed victim of Ms. Carswell.
Cruz.
Sorry, what did I say?
Carswell.
You said Carswell.
I guess I juxtaposed the names. Mr. Cruz, I have considered your request in light of the criminal history, specifically the criminal history involving Ms. Carswell and the facts that I've read in the petition for injunction for protection against violence and the prior probable cause affidavit. I am going to decline to release you on house arrest. I'm going to impose a bond in the amount of $25,000. There's to be no contact, again, with Ms. Carswell. That's sort of redundant, but I'm going to tell you anyway. Stay away from her.
I don't see her. I never see her. I stay away
Then
from
it shouldn't be a problem, sir. If you are able to post a $25,000 bond, you won't violate it if you don't see her. But nonetheless, contact is more than just seeing her. It's also emails, texts, phone calls, third-party contact, Twitter, Instagram, MySpace. Think of any other social media you might want to use. You basically have to pretend Ms. Carswell has never been a part of your life and does not exist. So
That's what I'm doing. I hope they do the same
bond,
thing.
no contact of any kind whatsoever with Miss Ruth Carswell. Good luck to you, sir.
There you go. Off you go. Down the middle, out the door. Judge, did you really just say MySpace?
Did I date myself? I don't use any of them. Technically, you are. You're here, Mr. Robinson? All right, Mr. Miller, we're going to do Benjamin Leon Robinson next.
Yes, sir.
That was a reset from this morning, I believe.
Have a seat outside
Yes, sir.
for the third time.
Good morning, Mr. Robinson.
Good morning, Judge. Good afternoon, I'm sorry.
I'm sorry, sir. Good afternoon. We reset you from this morning, so I don't remember what we did or didn't do. I'll just start from the beginning. You've been arrested for attaching a registration or license plate not assigned, driving on a suspended license, expired tag less than 6 months, aggravated battery causing great bodily harm, domestic violence, aggravated assault with deadly weapon without the intent to kill, domestic violence, There's a traffic warrant out for you in case number 13032-879 TC10A. And then I guess there's a outstanding capious for you for aggravated battery causing great bodily harm, domestic violence in case number 1510096 CF10A.
Now, Judge, is that an out-of-custody capious to which he'd be entitled to a bond, or is this a missing a court date capious?
If I may, Your Honor, it's a not in custody case.
Yeah, it looks like a not in custody, Mr. Miller.
Thank you, Judge.
So although it says no bond, it's really hold for magistrates.
And what happened, Your Honor, on the June 27th offense, there was a not in custody packet prepared. When he was picked up and Hollywood realized that he was in custody, they just charged him with the case that they had done the previous not in custody PC on.
Okay. And Detective, your name?
Detective Levy?
Levy, okay. And you're with Hollywood, I take it?
Yes, sir.
All right, raise your right hand. Swear affirm the testimony you're about to give is the truth and nothing but the truth?
Yes, sir.
What is it you'd like me to know, Detective Levy?
I just have concerns for the victim. His violence seems to be escalating towards her. He had, in previous case, broken her nose, and in this last incident, he brandished a knife, causing her fear, obviously, that he was possibly going to kill her, although he didn't say that. I'm just afraid for her safety and the safety of her child. He's escalating.
The broken nose is the June 27th incident?
I believe it's actually the May 20th incident.
Oh, the May 20th incident, okay. Right.
Those other two cases weren't specifically assigned to me, so exactly when he broke her nose, I believe it was May 20th.
Judge, just to be clear, none of this has ever been proven. These are all allegations at this point.
Duly noted, Mr. Miller. Okay, well, I've reviewed all the probable cause affidavits. I do find probable cause. Did you want to be heard on ties, Mr. Miller?
Yes, Judge, please, if I may. He's a 28-year resident of South Florida with strong family ties. He does have a job. He works at SWS. He has some money in the bank, no real estate. He does have a place to stay separate from the alleged victim. He'll be asking his friends to bond him out.
And, Your Honor, I provided the court with a copy of a 2013 probable cause affidavit alleging domestic violence battery against Mr. Robinson against the same alleged victim at a Hallandale. Now that was also dropped, Your Honor. I believe the significance is it's just another allegation of violence against the same victim, Your Honor. And as the court is familiar with, escalating violence is a common trait in relationships where there is domestic violence. My concern with this showing of escalating violence is that I believe the victim's safety is in danger, Your Honor, and I would be asking, in addition to whatever bond the court deems appropriate, a GPS monitor.
All right. On count one, there's no charge. Count two, the driving on a suspended license is a $100 bond. Count three, the expired tag, there's no charge. Count four, the aggravated battery causing great bodily harm is going to be a $15,000 bond. Count five, the aggravated assault with a deadly weapon without the intent to kill is also going to be a $15,000 bond. The traffic warrant is $500. Okay. And on count seven, the aggravated battery causing bodily harm, case number 1501096 CF10A, is also going to be a $15,000 bond. You're to have no contact directly or indirectly with Miss Jenna Pierre. Again, that means no contact of any sort, directly, indirectly, through any electronic communication or anything of the sort. And if you are released and able to post the bond, there'll be GPS monitoring to ensure that you stay away from Miss Jenna Pierre. He will.
Thank you, Judge.
Willie Pierre Charles.
Creole, please, Judge. We've already called. They should be here about 1:45.
All right, I'll put that aside.
Sit down, please.
Stephanie, I read somewhere there was a Spanish-speaking. We needed someone for Spanish too, I think. Did we call for that? They're on their way too? Great. Stephanie Pierce Steiner.
North Broward, Judge.
North Broward.
Good afternoon, Ms. Steiner. You've got a warrant in case number 15001-770-MM20A for $500. Good luck to you, ma'am.
That's it?
That's it. Good luck to you, ma'am.
Thank you.
You're welcome.
Thank you.
Caitlin Marie Flores.
She's present at the main jail, Judge. Declined the public defender.
Okay. Good afternoon, Ms. Flores. You're charged with 1 count of possession of cocaine and 1 count of possession of drug paraphernalia. I reviewed the probable cause affidavit. I find probable cause. There's a $1,000 bond on count 1. There's no charge for count 2. Good luck to you.
Good luck.
Alvin Ortiz.
Paul Ryan.
Good afternoon, Your Honor.
Good afternoon, Mr. Ortiz. You've got a misdemeanor capias warrant for case number 15001-296-MM40A in the amount of $500. Good luck to you, sir.
Sir, Your Honor.
Yes,
excuse
sir.
me. I've been incarcerated for 4 months. I didn't know anything about a capias. I was supposed to leave this morning, Your Honor. I finished my sentence.
Okay. Well,
I didn't know anything about a capias.
Who is this?
that must have been on something else. This warrant's here. I don't know anything about it.
Yeah, but
Judge, may I?
when was this capias from?
I understand.
Well,
but
it looks like it's from the Hollywood courthouse because of the case number.
Alvin
I think 40
Ortiz.
is Hollywood.
Any
may I be heard
chance I can get
briefly?
out of order on it, Your Honor, please? I mean, I already did
Mr.
4
Ortiz,
months,
hold
Your
on
Honor.
a second. I got to press a button so I can talk to the lawyer. There you are, Mr. Miller. Go ahead.
Thank you, Judge. This happens on occasion. What happens is they have a satellite case and they're in custody. Broward Sheriff's Office will not transport to any of the satellites, and so they're issued a capias. It's an easy matter of checking Odyssey to see if he was in custody when the capias issued.
You didn't have to. It's on the booking sheet. And if you look at the capias, Your Honor, it was issued June 30th, and from this, he's been in custody since June 2nd.
Okay.
So he.
Under that circumstance, Judge, we would just ask the court to go ahead and ROR him. I don't know if he has a court date or not.
Well, and Your Honor,
There's no court date on my paperwork. I don't know if there is one or not.
if I could just check something real quick.
Bear with us 1 second, Mr. Ortiz.
Thank you, sir.
Was that copy? No. Wasn't. All right, there it is.
Okay, this case has actually already been resolved, Your Honor. This was the hearing he didn't appear at was to show, I believe, community service hours. If he wants to convert to a civil lien, that way he doesn't have to come back to court. We don't have to worry about him possibly missing another court date.
You hear that, Mr. Ortiz?
Yes, sir. I don't understand. What exactly do I need?
Apparently, you were supposed to complete some sort of community service hours from whatever this case is out of the Hollywood courthouse. You
Okay.
did not. You've been in custody for, you said, 4 months.
Yes, sir.
So, Mr. Linder, what are we saying? Convert the.
If he wants to, yeah, you can just convert the court cost to civil lien, and he doesn't have to worry about coming back to court on this matter.
Yeah, I think that's what we're going to do. So, the case will be concluded. Any court costs you owe will be converted to a civil lien, and this will be off your back from now on.
All right, so I get to go home today. Then.
Ortiz.
Yes, sir.
Go home.
Well,
Thank
I can't
sir.
tell you today, but however long it takes to process you. Should be today, I would
That's
think.
okay.
But
Okay. All right,
Okay.
thank you, sir. Yes, sir.
He failed to appear at a hearing where he was supposed to show community service hours instead of his court costs. The judge just converted. Yeah, and the judge just converted the court cost to a civil.
Jesus Emmanuel Salas.
He's present at the main, Judge. He would like to plead this trespass case out if the court is so inclined.
Mr. Salas, you're charged with 1 count of trespassing an occupied structure or conveyance. in light of the facts in the probable cause affidavit, there seemed to be some sort of, unless I'm misreading it, domestic violence related issues, although I guess trespassing doesn't qualify as domestic violence. So I do find probable cause. There's a bond in the amount of $100, and I'm not going to be resolving it.
Thank you, Judge. I'm sorry, but he doesn't want to resolve it. You have to bond out. It'll be
Pierre Ernesto Gabriel. No, Mr. Shade, I didn't see you.
How are you, Judge?
Yours?
Judge, with regard to Mr. Salas, if the court would sign an order allowing him access to his telephone so that he can get a number to call to have someone bond him out.
Okay.
Thank you, Judge.
Caruso. He has one case on the docket. Is this Pierre Ernesto Gabriel?
It is, Judge.
Mr. Gabriel, you're
Judge,
charged.
Mr.
Go ahead.
I was just going to tell you he's interested in resolving all of his cases if the court is so inclined.
Okay, count 1, you're charged with operating without a valid driver's license. Count 2, improper taillights is a traffic infraction. Count 3, there's a warrant for a municipal ordinance in case number 12-005-888-MO40A. Is that what you're hearing, Mr. Shade?
Judge, I'm on just the open container. That's that's correct, from the 12 case,
Okay.
2012.
All right. Okay, Mr. Gabriel, you want to resolve these charges today?
What does that mean? I just get to go home and then everything's cool?
Everything's over with.
Okay, cool. Yeah.
Not sure I agree with your description of everything's cool. I mean, you're still going to be pleading to 2 crimes and a traffic ticket, and
Yeah, I think that's fine.
hopefully
that's good.
hopefully you learn not to do it again.
I did.
Okay. Count 1, the operating without a valid DL. I've looked at your driver's record. Although you don't have one, you still maintain any record of any activity, and there is none. Traffic ticket, and the other one is a old open container, you said, Mr. Shade?
Yes, Judge.
All right,
2012.
so if you'd like to resolve those cases, you understand you're giving up some very important rights,
Yes, I understand.
such as a right to a trial,
Yes,
right to have the state or the city prove the charges against you, right to produce your own witnesses.
I understand.
You want to give up those rights?
Yes.
And how do you plead?
Guilty? I guess, right?
No contest.
No contest, guilty?
Either one works. I'll accept that as a knowing involuntary plea, and I'll send it you to a withholding court costs on all 3 counts.
Thank you, Judge. Actually, if we ask the court to go ahead and dismiss the warrant, dismiss the infraction.
I can do that.
Thanks.
Count 2 will be dismissed.
Thank you, Judge. Mr. Shade also has a second look, Judge. Mr. Caruso. I just want to advise Mr. Shade that Mr. Caruso has an open case that has an active warrant on it, and he's wondering if they could resolve that as well.
Judge, I looked it up in the sheriff.org, and it only showed the one case, so I don't know, I don't think it's holding him. I can't tell that 100% though.
Kevin Caruso, is that you, sir?
Yes.
Yes, sir, sir.
Okay. Well, I show that the second look, you've been in custody 6 days for panhandling.
Yes, sir.
And what was your bond?
It was $250.
Okay, did you attempt to resolve this 6 days ago?
Yes, sir. I did bond out, sir.
You bonded out? Then what are you doing there?
He says I got a hold on me, a warrant. I'd like to clear that up.
You posted the $250 bond, though?
It was done this afternoon.
Okay.
It was in process as we speak.
Anybody show a hold
But-
on it?
I don't see it.
I'm sorry? Doesn't show your bond was posted either. How long does that take to show up in the system? When did you say you posted the bond?
This afternoon. It was about 12 o'clock. I
Less than
spoke
2
to the
hours ago.
deputy. He said, huh?
So less than 2
Yeah,
hours ago.
it was in process. When I spoke to the deputy, he told me it was in process.
Would you just rather resolve the case instead?
Well, I'd like to resolve it, yeah, but they say on an open warrant. I'd like to resolve that too. I'd like to go home today.
I don't know anything about an open warrant, sir.
Excuse me. Excuse me. Hello? He don't know nothing about a warrant.
And your lawyer is over there.
Oh, he said they don't know that there's no warrant.
And I was wrong.
Huh?
And I must have been wrong.
He must have been wrong then, he said.
Was that Mr. Miller who was speaking off camera?
Yeah.
He's never wrong.
I never said that, sir.
Well then, the
Hold on one
warrant.
second, sir. We're doing some heavy duty investigation here.
All right.
Yeah, there's another case that capias was issued on September 24th for interfering with city employee performance of duties.
So that's not an MO, right?
No, it's an MO.
That is?
It's an MO 40A. It originated, he was given an NTA late August.
And he didn't show?
No. Because his arraignment was the day after he was arrested on this.
Do you have a case number?
Yeah, I mean, I think the best.
So he didn't willfully not show.
No. If he wants to, the case number is 15-3214 MO 40A. If I may, Your Honor, is a friend of the court.
Okay. 15-3214 MO 40A.
Yes. The best.
Right. Mr. Caruso, as I said, Mr. Miller was right.
All right. Well,
there is a warrant for, there is a warrant for you in another city of Hollywood case. There's a warrant for you. Okay, listen. There's a warrant for you in another city of Hollywood case. Apparently, you were given a notice to appear to show up in court for interfering with a city employee. You didn't show up in court.
I never received.
Can I finish?
Go ahead, Your Honor.
You didn't show up in court because the day before you were supposed to show up, you got arrested for this.
Right.
So would you like to resolve both of them?
Yes, I would, Your Honor.
Okay, you understand by resolving both of them, you're giving up a slew of rights.
Yes, sir.
Okay? Particularly the right to a trial.
Yes, sir.
The right to have the city of Hollywood prove the charges against you.
Yes, sir.
The right to call your own witnesses if you wanted.
Yes, sir.
The right to show up and say, they never gave me that notice to appear.
Yes, Your Honor.
Okay, would you like to waive all those rights?
Yes, I would, Your Honor.
How do you plead?
No contest.
All right, I'll accept your no contest plea as to both cases. That's 15-010-063 MO10A and 15-003214 MO40A. It's a no contest plea on both cases. Sentenced you to an adjudication, time served as to both.
All right.
Should be all done.
All right, so, and the one I'm bonded out, do I get my bond back, or is that going to stay as a bond?
I have no opinion as to that.
All right,
Yes, Mr. Miller, he knows everything.
Well, what happens in that case, Mr. Miller?
I have no idea. Judge,
Do I take it to my bondsman when I get out about that?
Anything else, Steve?
Judge, I don't think so.
I mean,
All right, and I
If
think-
not, I'm sure the court can time serve whatever. It doesn't really need me here for these big monstrous cases.
We all interpret.
Take care.
How are you?
Talk yourself out of the country. Thank you.
Yes.
Good luck, Mr. Caruso. All right. Judge, just for the record, I'm putting that on my clip reel.
Okay. We have the interpreters here, so let's go with Mr. Wilney Pierre Charles.
Pierre Charles. He is on page 1 of your docket.
Good afternoon, sir.
Bonsoir, monsieur.
You're charged with 1 count of domestic violence battery.
Yo charge yon compte que ou tap goumen la kayo.
I reviewed the probable cause affidavit,
Te revize papye a.
and I do find probable cause.
Mwen gen cause justifiye ase.
Mr. Linder, any criminal history?
Li gen histoire criminelle deja.
He's currently out on resisting with violence and battery on a law enforcement officer.
Pour le moment, yo te lage nan prison parce que li ta pou yon charge que li te résisté police.
Case number?
15
Numéro 4 c'est 15
18
18
07
07
CF10A.
CF 10A.
Ça.
Okay, sir, I do find probable cause. I'm going to impose bond in the amount of $1,000
Ke map mette garanti ou pou $1,000.
in the new
$1,000
charges.
combien qu'on paye?
Ki so di?
Combien qu'on m'a payé $1,000?
With the $1,000, how much do I have to pay?
Typically 10% if you have collateral to make up the other 90%.
Mkwe ke se 10% sou gen ase kolateral pou mette lot 90%.
As a condition of your bond,
Pou kondisyon garanti ya,
you're going to have no contact with Mr. Jean Pierre Charles.
ou pa dwe pou gen aucun kontak ansam avè Monsieur Jean-Pierre Charles.
That's my blood. Et frère mi, m'avait pas de problème.
He's my brother.
Il te dit police la puis gars vinn nan la même police la pour te lever nan avec.
Ki sa?
Il te dit police la puis gars porter charge sur moi puis gars vinn nan prison avec.
He had told the police not to arrest me.
Okay. Well, until some other future court says otherwise, you're to have no contact with
Ok,
Mr.
jusqu'à ce que le tribunal passe en
Jean-Pierre
l'autre
Charles.
l'ordre, pour le moment, ou pas de pour qu'il aucun contact ensemble avec Jean-Pierre Charles.
And as I have found, you've
Mais c'est frère mi, nous m'avait été même côté.
But we are brothers and we live together.
Yeah.
I'm aware of that.
M'konnen ça.
As I found probable cause that you've committed a new offense while out on release in case number
Comme
15.
jwen cause assez que ou fait un lot crime pendant que ou te sorti dans prison sous caution.
018
Numéro cas 018
07
07
CF10A.
CF10A.
I'm going to revoke your bond on that case.
M'a retire garantie côté gain dans l'autre cas.
That's it.
Nous fini.
Mais ok, qui ça pour me faire? Est-ce que m'a blagué ou pas m'a blagué?
So what do I need to do? Am I going to be released or not?
Talk to Mr. Miller.
Parler ensemble avec Monsieur Miller.
Je ne parle pas français.
Oh, sorry about that, Mr. Miller. Well, you're being held no bond because your
Okay.
bond was revoked on the old case.
Ou prêté dans prison sans que ou pas ka payer caution parce que quand yo te retire ou te payer bon là-dedans là, qu'on y a pas gagné là-dedans encore, ou pas gagné garantie là-dedans encore.
If some judge in the future
Alors si on
lowers
l'autre
that,
juge t'a changé ça, pas de problème.
then you have a $1,000 bond on the other case.
Ou ap gagné pour payer $1,000 dans cas ça, dans cas nouveau.
Ok, mais m'gè pour m'aller, est-ce que m'a blagué? Si m'paye comme ça, si m'a blagué, et ça me besoin connaître parce que
Can I explain to him, Your Honor, because he's asking the same question again? Ou te gon l'autre cas déjà que yo te lago? Est-ce qu'on connaît ça?
yeah, me connais
Ok,
Kata, mais
kasa yo te lago la den lan, yo remet ou nan prison parce que ou violé, parce qu'on fait yo arrêter encore. So,
non,
premier
parce
cas,
que frère la police là raciste parce que police frère nan depuis gars arrêté mais arrêté.
nous pas dans cas ça. Pour cap frère ou gain caution $1,000. Mais
Ok, si me paye comme ça, est-ce que m'a blagué?
ou ka lage mais yo réarrêter encore pour premier cas. Et premier cas ou pas gain caution.
Premier cas ça qu'on y a là?
Non, l'autre là. L'autre que te sorti dehors, yo réarrêter encore.
Non, yo pas jamais, c'est qu'on je dis yo arrêté, pas jamais arrêté.
Beating a dead horse.
Okay, thank you, sir.
Merci, monsieur.
Est-ce que tu me paye comme là m'a blagué? Dis-moi.
Non, pas blagué.
Yo pas bon? No bon?
Non.
Giovanni Melendez.
North Driver, you need the Spanish translator.
Good afternoon, sir. Good afternoon, Mr. Melendez.
Buenas tardes, señor Meléndez.
¿Cómo está?
How are you?
I'm fine, thank you.
Bien, gracias.
You are charged in count 1 with driving under the influence of alcohol, first offense.
Usted es el encargo número 1 por conducir bajo los efectos, su primera falta.
Count 2, driving under the influence with an unlawful blood alcohol level.
Y segundo, es manejar bajo los efectos con un nivel excesivo de alcohol en la sangre,
Above a .15.
más allá del límite .15,
operating without a valid driver's license,
manejando sin una licencia válida de conducir,
and a traffic ticket for going too fast.
y un ticket de tránsito por exceso de velocidad.
I've reviewed the probable cause affidavit.
Yo revisé el affidavit de motivos fundados.
I find probable cause.
Veo que si hay motivo fundado.
There'll be a bond in the amount of $500 on count 1.
Por el cargo número 1 habrá una fianza de $500.
$1,000 in count 2.
Por el cargo número 2, $1,000.
And no charge in counts 3 or 4.
Y en el cargo 3 y 4 no habrá más cargos.
So your total bond is $1,500.
Así que el total de su fianza son $1,500.
Okay.
Tenga buen día, señor.
Mental health
Okay. And order a mental health screen.
Y una evaluación de salud mental también.
Anybody else need the services of a Spanish interpreter?
¿Alguien más necesita los servicios del intérprete en español?
Sí. Sí. Who said sí? No? Okay. North Broward? Oh, that was the guy we just did. Oh, you just did it? Thank you, sir.
Gracias, señor.
Thank you, sir.
You're welcome.
Andres Sanchez Guillen.
Bonded judge. Christopher Dell. Come on.
Yeah.
Mr. Dell, good afternoon. You're
Hey,
charged with one
let
count
me-
of trespassing, an occupied structure, or conveyance.
Judge, Mr. Dell is interested in resolving this case if the court is so inclined.
Okay, Mr. Dell, you understand by resolving this case you'd be giving up a series of rights?
After.
Yes? You understand you have a right
Yes.
to a trial?
Okay, that's fine.
Are you not hearing me, or are you just not answering me?
Yes, I hear you.
Okay, you understand you'd be giving up a right to a trial?
Yes.
Right to call your own witnesses?
Yes.
The right to be presumed innocent and have the state of Florida prove the charges against you?
Yes.
You understand you're
Yes.
going to have to stay away from the Plantation Inn?
Yes.
I'm just going to just keep getting arrested if you go back.
Nah.
I think you will, but you just need to stay away. Okay, how do you plead, sir?
No contest.
No content.
Okay, I'll accept that no contest plea as a knowing and voluntary plea. I sent it to adjudication and time served.
Thank you, Judge.
Good
Okay,
luck to you,
you're done. Good luck.
Roderick James.
Paul Ryan.
Paul Ryan.
Yes, Your Honor.
Good afternoon, Mr. James. Got a violation of probation warrant in case number 07023-643 CF10A. There's a no bond hold on that. You have a hearing in Division FA on Wednesday at 8:30 in the morning.
Yeah, and I can.
Good luck
What
to you,
kind of
sir.
violation is it, sir?
I'm sorry?
What kind of violation is it?
I don't know if the warrant's here, but I could tell. Here it is. Let's see. It says. You refuse to submit to electronic monitoring. You fail to comply with all instructions given to you by
Exactly.
whoever New Beginners is. And then there's some monetary conditions. So you didn't listen to the people at New Beginning, you didn't get electronic monitoring, and then there's some financial stuff. That's what's in the warrant, sir.
That's what I'm here for now already, sir.
Okay? Well, you'll have a hearing on that case on September 30th. And you're being held no bond
Excuse-
until the judge says otherwise.
What date is the violation?
Did you not get a copy of your violation of probation warrant?
No, sir. I was told that I'm already here on that and another violation.
Well, I'm just
So
looking
you're
at the
telling me I
warrant.
got-
It says July 27th was the date you refused to submit to electronic monitoring. June 3rd of 2014 was the violation of beginners, sorry. And then, and the August 20th is the date of the financial conditions. And that's the same date that the warrant
August 20th
was
this
signed.
year?
That's the same date the warrant was signed.
August 20th this year or last year?
This year, sir. Okay?
Yeah, and my court date is when?
Wednesday.
Wednesday?
Yeah, 2 days.
All right, thank you, sir.
Okay, good luck to you, sir. Admiel Cain Fredericks.
Mr. Fredericks is present at the main jail.
Good afternoon, Mr. Fredericks. You're charged with 1 count of possession of PVP, 1 count of riding a bike with no lights or improper lights. I reviewed the probable cause affidavit. I find probable cause. There's a $1,000 bond on count 1. No charge for count 2.
Thank you, Judge.
Thank you, Judge.
Okay, Mr.
Tyler
King.
Brent King.
Main jail judge, decline the public defender's services.
Okay.
Oh, what?
Good afternoon, Mr. King.
Good afternoon.
You've been arrested and charged with count 1, possession with the intent to sell, manufacture, or deliver marijuana. Count 2, driving under the influence of alcohol, first offense. Count 3, driving under the influence with damage to person or property of another. Same thing in count 4. Count 5, leaving the scene of an accident involving damage to property. And count 6, careless driving. I reviewed the probable cause affidavit. I find probable cause. You have a bond in the amount of $1,000 in count 1, $500 in count 2, $1,000 in count 3, $1,000 in count 4, $100 in count 5, and there's no charge for count 6.
Thank you, Judge.
Dale,
Hold on, Mr. Miller. Hold on, Mr. Miller.
Oh, sorry. Judge still wants to say something.
Okay.
Mr. King, they're telling me that you're eligible for pretrial release. If I put you on pretrial release, you wouldn't have to post any money to get out, but you would have to follow the rules and conditions of the pretrial release program. In this case, that means telephone contact twice a week. You'd have to submit to drug testing by way of urinalysis at your own expense. What was the last condition?
No driving without a valid driver's license.
And no driving without a valid driver's license. Understand?
Yes.
I know you're saying yes because it sounds like a great deal you can't pass up. But if you say yes and go on pretrial and you continue to smoke marijuana or drink or do any of those things and you test positive, you're going to be standing right where you are. Only this time will probably be a no bond.
Okay. Thank you.
You want to do the pretrial
You need
release?
to be there before noon tomorrow.
Before noon tomorrow.
If you get out before 4 p.m. today, go there today. Otherwise, before noon tomorrow. Off you go.
Thank you.
Good luck.
Good luck to you, sir.
Thank you.
Vilner, Petio, Your Honor. Roger.
Vilner Petois?
Yes, sir.
Did I say that right?
Yes, sir.
Oh.
You said it right, sir.
Good. Charging count 1, battery on an officer or firefighter, possession of marijuana less than 20 grams, and resisting or obstructing an officer with violence. I reviewed the probable cause affidavit. I do find probable cause. Mr. Linder, any criminal history?
One moment, Your Honor. Pulling it right now, Judge.
Sure.
DUI in 2014.
Okay, it is what it is.
Grand theft. This is out of date. Grand theft. Credit card fraud and possession of cannabis. 2011 out of date. Adriana Leo and 2011 out of date. Possession of cannabis with intent, resisting without violence, out of date, 2011. Possession of, never mind.
That's it?
Yeah, he had a lot of tires, but most of them were all dropped.
Okay. All right, I find probable cause will be a $7,500 bond on count 1. There's a $100 bond on count 2. And there'll be a $7,500 bond on count 3. So that's a total of $15,100. Good luck to you, sir. Roderick
Good
Carl
luck to you,
Shan.
sir. Main jail? Okay, sir. What's the 10% of the... 1 second.
Good afternoon, Mr. Shan. You're charged with count 1, false ID given to a law enforcement officer. And then there's a warrant for violating your community control in case number 13-003-621 CF10A. There's no charge for count 1. There's a no bond hold in count 2. And you have a hearing in Division FB on Wednesday at 8:30 in the morning. Good luck to you, sir.
Thank you, Judge. That clears us at the main jail.
All right.
Always a pleasure.
See you next week.
We'll see you next Monday.
Who's that? Oh, whatever.
Marquez Allen.
Paul Ryan. Kenneth Martin.
CTC. Second one.
Good afternoon, Mr. Allen.
This is Mr. Martin.
Oh, I said Marquez Allen, but
Okay,
let
no.
me see who you got there. Wait, we'll do Mr. Martin if he's there.
Yes.
Kenneth Martin?
Yes.
Okay, Mr. Martin, you were arrested for possession of PVP and possession of marijuana in 36 days.
Your Honor, he can be ROR charged.
Mr. Martin, State of Florida informed me they have not filed charges against you within the requisite 30-day time frame. Therefore, you're entitled to a release on your own recognizance. So you should be ROR'd. Good luck to you, sir.
Okay.
All right, so we'll try that again. Marquez Allen or Marcus Allen. All right, well, that was the second look on the... That's what I see. There's nothing to do there since I don't have Mr. Allen. Michael Fletcher.
Conti, Your Honor.
Good afternoon, Mr. Fletcher. Looks like you've been in custody for 103 days for possession of PVP.
he can be. We picked up another case. He can be ROR on both.
He's got 2.
Yeah, he's got 2 cases on the docket.
They're both under Fletcher.
Yes.
All right, so you've got another case where you've been in custody 34 days on the possession of PVP, but the state of Florida has informed me they have not filed charges against you within the required 30 days. That means you're entitled to an ROR, so you will be ROR'd on both cases. Understand?
Yes, sir.
But you also have to stay away from the flocka, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, sir.
Neil Hancock.
Conti, Your Honor.
Good day, sir.
Good afternoon, sir. You're in custody for 39 days, a criminal mischief over $1,000.
He can be ROR, Judge.
State of Florida has not filed charges against you within the requisite 30 days, and they tell me you're entitled to an ROR.
Okay.
So good luck to you, sir. If there was any no contact order previously given as a condition of your bond, that's still in place.
Correct.
Okay?
Yes, sir.
Good luck to you, sir.
Thank you.
Barbara King.
Paul Ryan, Judge.
Good afternoon, Ms. King.
Good afternoon, Your Honor.
Looks like you've got 2 aggravated stalking after injunction and a criminal mischief over $1,000. You've been in custody 37 days.
Just proof of filing.
Oh,
Your
it's
Honor,
filed?
from the yeah, just
State of Florida has filed charges against you, so whatever your bond is will remain your current bond, and you'll be getting a court date rather quickly.
Okay, Your Honor, the restraining order is agreed upon restraining order, and I know the stipulations. I didn't violate them. I was in an establishment and
Ma'am, don't talk about the fact you're not going to win a trial here today. You got to speak with your attorney because everything is being recorded here, so I advise you not to talk about the facts of your case. Meet with your attorney in private and discuss that issue with them.
Okay, so I'm just
Okay.
waiting on a court date?
For the
You're
other
gonna
case?
get an arraignment date where the judge will formally pronounce the charges.
Different judge, not me.
Not Judge Sikora.
And so if you do have a bond, you can post it if you have the ability to do that. And
It's very
if there's
high.
any no contact orders in place, which I would imagine there are since this is a stalking, you have to abide by those no contact orders. Okay?
Of course. Okay.
Good luck
Thank
to
you,
you,
Your
ma'am.
Honor. Thank you. You go ahead. Back to you. Go back.
Lucretia Smith.
Paul Ryan.
Good afternoon, Ms. Smith. You've been charged with one count of battery on an officer and disorderly conduct. It's like fighting. You've been in custody 35 days. The state of Florida has filed charges against you, so whatever your present bonds are, they will remain in place. Okay?
Okay, so I have to stay here?
Well, you can bond out, or you can stay there and wait until you'll get an arraignment date relatively soon, I would think. And you'll get a court date in front of whatever judge will be handling your case.
So I have to wait till the next judge.
No, you can bond
Handles
out.
my case.
You can bond out
Well,
in the interim.
the reason I haven't bonded out yet is because my
problem.
mother has my money and she don't want to bond me out.
Okay, well,
And I'm dealing with DCF and I haven't seen my kids and I can't finish my case because I'm here.
okay, well, like I said, you will be getting a court date relatively quickly. If you qualify for the public defender's office, you'll have a lawyer appointed for you, and you'll be able to get all that worked out.
Okay.
Good luck to you, ma'am. Michael Caballero.
North Broward.
Mr.
Hello, Your
Caballero.
Honor. Yes, sir.
Been in custody 35 days for a grand theft.
And, Your Honor, we have not yet filed an information. He's entitled to release.
Okay, Mr. Caballero, the state of Florida has not charged you formally within 30 days as required by law, so you're entitled to an ROR.
Thank you, sir.
Good luck to you, sir.
Thank you.
Tavares Carter. Tavares Carter.
Okay, here's the... Here's the problem. He's entitled to an ROR. My concern is, and I would, if assuming he was there, I would have been asking the court to remind him that there's a no contact order in place. Just trying to see what facility he's at. I don't understand. He's in Maine. I don't understand how Maine never has anyone for the 30 days. It's not they don't always. This is like 3-4 days in a row now. And they have the second look people. They don't have the 30-day people.
All right, we'll reset Mr. Carter for
The
tomorrow.
problem is we really can't judge because he's entitled to an ROR right now. Is there anyone still there at Maine? I understand. Can we see? Is there anyone we can call over to Maine to have him?
Vaughn Gardner.
Hey, March, hold on for 1 second, please.
I have to make a call on two, that's why I'm... Oh, Vaughn Gardner, Mr.
Mark.
Oh, that's this. I don't see him anywhere anyway. Okay. Charges have been filed.
And I'm. Yeah. All right. Okay. Thanks. It's getting ridiculous.
No, this is not Tavares. Is it the same guy? Carter? They're both
Another one is Tavares Carter.
Okay. Tavares Carter is the one.
I guess Gardner also.
I'm looking for 541 500.
You can call him. I don't think it's as crucial as charging a file.
I understand that, but he should know.
No, I agree. I don't have a problem with that.
And they also need gardener.
Lawn gardener.
Hello?
The other one is in 5 Charlie. Vaughn Gardner is in 5 Charlie.
Hey, John, what's up?
No, I did.
Gardner we can reset.
No, I know.
He's not going anywhere.
Resetting your own?
Gardner we can reset for tomorrow.
Okay, listen. Don't worry, Nick's Gardner, just bring cars up. Just bring the one from Fort Delta.
Yeah, I'm.
Nick and the Gardner will reset for tomorrow. All right, and I'll start sending you my document if I get it in time.
Slowly, surely. That's him. Yeah. It's part of our job responsibilities. I'm kidding. Just relaxing.
We're gonna start it now.
Are you Tavares Carter?
No.
Yes, sir.
Okay, Mr. Carter, I guess you've been held for, let me go back to my page here. Got here quicker than I expected. You've been held for 35 days on aggravated battery. Looks like knew or should have known somebody was pregnant.
Yes, sir.
The state of Florida has not filed charges against you within the requisite 35 days, so you are entitled to a ROR. Understand that if there was any no contact order that was put in place with your initial bond, that's still in effect. So
Yes, sir.
The no contact order is still in effect. If you violate the no contact order, your ROR can be revoked and you'll be standing right there again, okay?
Yes, sir.
I don't have the name of the victim in here, but I'm sure you know who she is.
Diamond Butler.
Yes, sir.
Diamond Butler, they just told
Yes,
me.
sir.
So have no contact directly or indirectly with Diamond Butler. No phone calls, no drive-bys, no emails, no texts, no tweets, no IMs, none of that stuff, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, sir.
Have a good day. And at 2:35 on Monday, September 28th, that concludes our afternoon docket.